Please subscribe and ring the bell to be instantly notified of In Hindsight /Balik Tanaw episodes. Please like and share this video and all my videos across social media. Please support the show on PayPal, where you can give out any amount you want, or on Patreon. Patrons can watch Balik Tanaw /In Hindsight videos earlier than everyone else. They can see their names at the end of videos, and they can even request videos about a song, a movie, an album, a TV show, or even on one-hit wonders. For full details and to become a patron, visit patreon.com/baliktanaw. And thank you to my sibling G-G Arts for the microphone I borrowed for this video. Welcome, I am Emir, and let's look back in hindsight. I showed a list of anime that I wanted to talk about on this show on my video on Samantha, a mod for Everlasting Summer, a visual novel. Since then, I haven't talked about any of them, nor have I made any video on anime. Instead, I keep putting on my videos Error 404. Fair use not found in Japan. How important is fair use? Fair use allows the use of any copyrighted work for criticism, comment, news reporting, teaching, scholarship, research, and similar purposes without any fear of being sued or taken down for copyright infringement or violation of copyright. Fair use also protects parodies and transformative works, as the United States Supreme Court ruled in Campbell versus Akuf Rose Music Incorporated. Since Japanese law does not have a fair use section, I'm afraid to review any anime, or for that matter, any Japanese media on this show. Today, join me as I explain further. This is another Law Meets Balik Tanaw video. What I will be saying also applies to cosplaying characters from Japanese anime, and to fan art, and to parodies, and even to memes. Part 1. Why Japanese Law? Conflict of Laws. Now, you'd argue, wait a minute, why would Japanese law apply? I'm not in Japan. I'm not Japanese. As far as you know. But what if the media I want to review was made in Japan? Why would Japanese law apply then? My viewers, I'd like you to meet conflict of laws, or as it is called where I studied, private international law. The Cambridge Dictionary defines, quote, conflict of laws, unquote, as, quote, a legal disagreement in which a law court must decide whether a judgment should be made according to the laws of one country, state, etc., or another, end quote. As the Legal Information Institute, LII, of Cornell Law School states, quote, the question to be asked by one concerned with conflict of laws is, what law should be applied to the case at hand? The process by which a court determines what law to apply is sometimes referred to as, quote, characterization, unquote, or, quote, classification, unquote. The determination must be made in accordance with the law of the forum, end quote. The forum is the court or body where any case is pending. The LII continues, quote, courts faced with a choice of law issue generally have two choices. A court can apply the law of the forum, lex fori, which is usually the result when the question of what law to apply is procedural. Or, the court can apply the law of the site of the transaction, or occurrence that gave rise to the litigation in the first place, lex loci. This is usually the controlling law selected when the matter is substantive, end quote. What does all of this mean? Even if the case against me is filed here, which is not in Japan, nothing is stopping the court from applying Japanese law. It can rule that the law of the rising sun applies because the media involved is created in Japan by Japanese. To support its position, the court can cite a reciprocity section in that country's copyright law, in the copyright law of the forum. For example, the Philippines, where I'm from, has a reciprocity clause in its copyright law. I mean the Intellectual Property Code. Code: any person who is a national or who is domiciled or has a real and effective industrial establishment in a country which is a party to any convention, treaty, or agreement relating to intellectual property rights or the repression of unfair competition, to which the Philippines is also a party, or extends reciprocal rights to nationals of the Philippines by law, shall be entitled to benefits to the extent necessary to give effect to any provision of such convention, treaty, or reciprocal law, in addition to the rights to which any owner of an intellectual property right is otherwise entitled by this act. End quote. If the case is filed here in the Philippines, can I argue that what applies is the law of the forum, where the case is filed, which is Philippine law? Of course I can. We can always argue, but whether we will succeed is a different question. This is one thing I can't argue. Copyright law is a procedural law, so the law of the forum should apply. The matter of copyright is not a procedural law. What is procedural law? The LII definition states that it is the code, law that establishes the rules of the court and the methods used to ensure the rights of individuals in the court system. In particular, laws that provide how the business of the court is to be conducted. End quote. Copyright does not determine how the business of the court is to be conducted. Copyright does not establish the rules of the court. While copyright is a right, hello, Captain Obvious. It does not concern the methods to enforce or ensure this right. What can I argue then for the application of Philippine law and not Japanese law? I can argue, quote, the foreign law ordinarily applicable will not be applied in this case because to do so would violate our public policy, end quote. But how would the application of Japanese copyright law on cases concerning copyright infringement of Japanese-created media violate Philippine public policy? I can argue that the lack of fair use under Japanese law violates Philippine public policy, since the copyright law of the Philippines, I mean the Intellectual Property Code, includes fair use. But that would seem to be putting the cart before the horse. Fair use is a defense. It is a defense under copyright law. The copyright owner insisting on the application of Japanese law can argue that the question of what the applicable law is has to be answered first before even considering fair use, a defense which may not even be available under the applicable law. If the court applies Japanese law, then the next question is, did I commit copyright infringement? That is for the copyright owner to prove. If the copyright owner succeeds, then the next question is, what is my defense if I'm sued for infringing copyright for, let's say, making a review of an anime? I look now to Japanese law. Part 2. Current law and possible limitations to copyright. Instead of a fair use section, the Japanese law on copyright contains an enumeration of limitations of copyright. If any of these are present, then there is no copyright infringement. Let's go to the limitations one by one. Note that while the English translation is provided by the Japanese government, the English text is not official. The Japanese text prevails. 1. Reproduction for private use, meaning for personal or family use or for any other use of a similarly limited scope. Article 30-1. 2. Exploitation of, quote, incidentally captured works, unquote, a term which refers to any other work comprising objects or sounds that are captured incidentally because it is difficult to separate them from the objects or sounds being captured during the photography or recording. Article 30-2. An An example would be the background noise while I'm recording this video. 3. Exploitation of a work as part of the investigation process. Article 30-3. 4. Exploitation of a work, but not for the purpose of enjoying the thoughts or sentiments expressed in that work, or if it is done for use in testing, to develop or put into practical use technology that is connected with the recording of sounds or visuals of a work or other such exploitation, or if it is done for use in data analysis, or if it is exploited in the course of computer data processing, or otherwise exploited in a way that does not involve what is expressed in the work being perceived by the human senses. Article 30-4. 5. Reproduction in libraries and similar facilities, meaning as part of non-commercial undertakings at the National Diet Library or at a library or other facility specified by cabinet order whose purpose is to offer books, records, and other materials for the public to use in the cases enumerated in the law. Article 31, Paragraph 1. 6. Quotation of a work that has been made public, which must be consistent with fair practices and within a scope that is justified for the purpose of news reporting, critique, study, or other place in which the work is quoted. Article 32, Paragraph 1. 7. Public relations materials, research or statistical materials, reports, and other similar works which have been prepared by a national or local government agency, incorporated administrative agency, or local incorporated administrative agency, with the goal of making them widely known to the general public, and have been made public under the authorship of such agency, to be reprinted as explanatory materials in a newspaper, magazine, or other printed publication. Article 32, Paragraph 2. 8. Printing of works in textbooks. Article 33, Paragraph 1. 9. Reproduction in order to prepare a large print textbook for children or students who have difficulty using such a work printed in a textbook due to a visual impairment, developmental disorder, or other disabilities. Article 33-2. 10. Broadcast of educational programming for schools. Article 34. 11. Reproduction in schools and other educational institutions, except one founded for commercial purposes. Article 35, Paragraph 1. 12. Reproduction as examination questions. Article 36, Paragraph 1. 13. Reproduction for persons with visual and vision-related impairments. Article 37. 14. Reproduction for persons with hearing impairments. Article 37-2. 15. Stage performances for non-commercial purposes. Article 38. 16. Reprinting or broadcast or cablecast or reception of the broadcast transmission of and simultaneous transmission via automatic public transmission of editorial commentary on political, economic, or social current affairs that has been printed and published in a newspaper or magazine. Article 39. 17. Exploitation of political speeches or statement delivered in public or a public statement given in the course of judicial proceedings, including one given in the course of a hearing by an administrative agency or other proceedings equivalent to a trial. Article 40, Paragraph 1. 18. Printing in a newspaper or magazine of a speech or statement that has been delivered in public by a national or local government agency, incorporated administrative agency, or local incorporated administrative agency, or the broadcast or cablecast of such a speech or statement, or the reception of a broadcast transmission of such a speech or statement, and its simultaneous transmission via automatic public transmission. Article 40, Paragraph 2. 19. Reporting of current events within a scope that is justified for the purpose of news reporting. Article 41. 20. Reproduction for judicial proceedings or for internal use by a legislative or administrative organ. Article 42, Paragraph 1. 21. Reproduction for proceedings involved in a patent, industrial design, or trademark examination, the technical valuation of a utility model, or an international examination or preliminary examination for an intellectual application under the Patent Cooperation Treaty, Act No. 30 of 1978, by an administrative agency. Article 42, Paragraph 2, Subparagraph 1. In short, proceedings involving other intellectual property rights besides copyright. 22. Reproduction for proceedings regarding an administrative agency's or incorporated administrative agency's examination or investigation of pharmaceutical affairs. The pharmaceutical affairs include particulars of medical equipment and regenerative medicine products, or proceedings regarding a report about pharmaceutical affairs submitted to an administrative agency or incorporated administrative agency. Article 42, Paragraph 2, Subparagraph 2. 23. Exploitation by the head of an administrative organ or an incorporated administrative agency, etc., local government agency, or local incorporated administrative agency for disclosure pursuant to the Act on Access to Administrative Organs Information, Article 42-2. 24. Reproduction by the head of the National Archives of Japan, etc., or the head of the local archives, etc., of a work associated with the historical public records and archives to preserve the historical public records and archives. Article 42-3, Paragraph 1. 25. Exploitation by the head of the National Archives of Japan, etc., or the head of the local archives of a work by each of the means provided for in stated portions of the Public Records Management Act or Public Records Management Ordinance to make it available or present it to the public. Article 42-3, Paragraph 2. 26. Reproduction for collecting internet materials and online materials under the National Diet Library Act, Article 43. 27. Ephemeral fixation by a broadcaster or cablecaster, Article 44. 28. Exhibition of an artistic work by the owner of the original, Article 45. 29. Exploitation of an artistic work on public display, except for the purposes stated on the article, Article 46. 30. Reproduction in connection with the exhibition of an artistic work, Article 47. 31. Reproduction in connection with an offer to transfer an artistic work, Article 47-2. 32. Reproduction by the owner of a copy of a work of computer programming for the person to execute the work on that person's own computer, Article 47-3. 33. Exploitation of works incidental to the exploitation of works on a computer, Article 47-4. 34. Minor exploitation incidental to computerized data processing and the provision of the results thereof, which covers using a computer to search for the title or author name of a work, or undertaking computerized data analysis and furnishing the results of that analysis, or an action that Cabinet Order prescribes as contributing to increased convenience in the lives of the citizenry by creating new knowledge or information through computerized data processing and making the results of this available beyond what is set forth in the preceding two items, Article 47-5. 35. Exploitation by means of translation, adaptation, or the like, Article 47-6. And 36. Transfer of copies made pursuant to restrictions on the right of reproduction, Article 47-7. Wow, that's a long list of limitations to copyright, but I mentioned every single one of them for a reason. These are the only limitations to copyright. These are very specific. If you notice, they only apply to certain people, to certain institutions, to certain processes, or for certain purposes. According to Yi-Young Chang, please correct my pronunciation by commenting on the YouTube page of this video. Quote, the conventional theory has interpreted that copyright exception is, quote, only an exception to the principle, unquote, and it should be interpreted strictly, end quote. What is the effect? I quote Chang again. Quote, if copyright exceptions are interpreted strictly by courts, most daily use might be copyright infringements, end quote. None of these copyright exceptions are as broad as fair use. According to Teruo Doi, please correct me again by commenting on the YouTube page of this video, I quote, in at least 2 copyright infringement actions filed with the Tokyo District Court and Nagoya District Court in 1994 and in 2004, respectively, the court denied the alleged infringer's defense of non-infringement based on the, quote, fair use, unquote, doctrine, other than those instances of limitations and exceptions provided in the Copyright Act. In Keiki Gakushu Kenkyusha versus Keiki Daisan Shokan, pardon the pronunciation, the Tokyo District Court held that the Copyright Act sets forth in Article 30 to Article 49 various instances of limiting copyrights and conditions for such limitations in detail for the purpose of balancing the private rights of authors, etc., and the public interest of allowing other persons to exploit works of authorship in fair and equitable terms, and therefore, the Act does not contain a general provision equivalent to the, quote, fair use, unquote, doctrine, with the legislative intention to provide limitations in instances provided in these provisions. In Jasrak versus KK Chuge et al., again, sorry for the pronunciation, the Nagoya District Court held that, in view of the objective of the Copyright Act provided in Article 1, and a set of provisions beginning from Article 30 to provide limitations on copyright in accordance with the objective of the Act under the legal system of Japan, limitations must be expressly provided in the statute, and there should be no instances of fair use of works aside from such express statutory provisions. End quote. If there is any doubt whether Japanese law includes fair use as a limitation to copyright, the court decisions mentioned should make it clear. Under Japanese law, there is no fair use. Error 404. Fair use not found. Part 3. Proposals for fair use under Japanese law. The article by Teruo Doi mentions that, quote, does the Japanese Copyright Act need a general, quote, fair use, unquote, clause? Has become a topic of much discussion in Japan since a report on, quote, possible approaches to be taken to make the intellectual property system better adapted to the digital network age, unquote, was released on November 27, 2008 by an intellectual property expert group appointed by the Intellectual Property Strategy Office of the Cabinet, end quote. However, more than a decade later, Japan still doesn't have a fair use section that is the same or at least similar to the fair use section in the United States Copyright Act. Yi-Young Chang lists down 3 possible ways of introducing fair use in Japan. 1. Flexible construction, where courts broadly interpret the law. 2. A general provision of copyright limitation. Or 3. Addition of new copyright exceptions. Yet, with these options, there doesn't appear to be a push, a critical mass, towards the adoption of fair use in Japanese law. Part 4. Is fair use worth it? Here's my 2 cents. Yes, a fair use section is worth putting in Japanese law. The existing limitations or exceptions to copyright simply don't cover the many ways by which people have used copyrighted materials. For example, parodies, which under the US style fair use law is not considered copyright infringement, would be under Japanese law. I'd argue that even reviews, like those I've been doing on Philippine and American media, would be considered copyright infringement under Japanese law. Now, you may argue that, wait a minute, copyright does not include the right to control reviews or criticisms of a work. That's why libel laws exist. That's correct. Though libel laws protect the reputation of a person and not the reputation of their work. However, it's unavoidable for a review to show portions of the work involved to illustrate and explain. Take the case of Todd in the Shadows. His videos feature segments of the song he's reviewing and other songs, and sometimes even portions of movies, television shows, and news clips. Because of this, some of his videos get taken down due to copyright claims. That happens regardless of his thoughts on a song. That's why I only put pictures of the media I'm talking about in my reviews. That's why I sing portions of a song I'm discussing, instead of putting a part of the recording or of the music video. Yet, without fair use, those steps may not be enough to get me off the copyright hook. It's not worth spending time watching and rewatching episodes of an anime, writing scripts, recording audio, editing the video, and uploading it online, only for it to be taken down. This is the reason I haven't done a review of any anime yet. The disincentive becomes greater when the copyright owner is overly protective of copyright. Let me introduce you to the official social media accounts of the show. Always stress the words quote by official licensor, unquote, or quote licensed by, unquote. So, if I were to make a negative review of the show, which I won't since I like it, anyway, if I were to make a negative review, then there's nothing stopping the copyright owner or its licensor from demanding that I take my review down. Making a review of a copyrighted material is not among the exceptions or limitations of copyright under Japanese law, meaning I can be held liable for copyright infringement. See how important fair use is? See how it opens up more than just a wiggle room? I can defend myself in court, yes, but at that point, we move from legal to practical considerations. What happens if the case is filed against me in Japan? Can I afford to go there? Even before considering that, can I even go there? I'm sure that by the time this video comes out, there are still travel restrictions. Can I afford Japanese lawyers to argue my case? If I did, I wouldn't have to ask you to support the show on Patreon or on PayPal every single video. What if I'm sued here in the Philippines where I live? Can I afford to defend myself? I'm just one person. I am no law firm. Copyright owners would engage the services of lawyers who have access to a wide range of legal sources. I just have Google Scholar. What if I lose? Can I afford to appeal? It's not just money involved. It's also time. I could otherwise spend my energy and time reviewing other media, Philippine media for example. At least the Philippine Intellectual Property Code has fair use. What about that, quote, current affairs, unquote, limitation to copyright? If you know the story of you'll know what I mean. That would be a stretch though, because isn't primarily a commentary on politics, on world affairs. I guess I can do a review of but without including any pictures from the show, or merchandise, or related media. But, let's be honest, my dear viewer, would you be able to relate? Would you get it? I doubt it. It's not just reviews which are affected by the lack of fair use. What about cosplay? Fans who dress up like their favorite characters are not thinking about violating copyright. They love these characters. They don't want to harm, to prejudice the copyright owner. Yet, under Japanese law, they would be violating copyright infringement. Same goes for fan art. What about fan songs, fan videos, fan dubs, memes? Same thing. Unless intent to infringe is an element to be held liable for copyright infringement under Japanese law. I'm not aware if it is. Please comment on the YouTube page of this video to correct me. And it's not just anime. Any movie, show, song, album, game, any media created in Japan or by a Japanese would be covered by Japanese law, which has no fair use clause. If the use doesn't fall under any of the exceptions stated in the law, then it's copyright infringement. Even if the use is by devoted fans who want to show their love for the media concerned. Part 5. What about Everlasting Summer? But you may remember my video on the Samantha mod for Everlasting Summer. That may not be an anime, but it's in anime style. Why did I talk about that? 1. That mod and the game were created in Russia by Russians, so Russian law and not Japanese law applies. But I know what you're thinking. Is there fair use in Russia? No, there isn't any fair use law in Russia either. The Russian law on copyright enumerates specific exceptions to copyright, just like Japan's. What's my excuse? Here's the thing. Everlasting Summer, the game itself, is licensed under the Creative Commons Attribution Non-Commercial Share Alike 4.0 International License. I'd do a Creative Commons video someday. Or, if you can't wait, there are lots of videos on Creative Commons right now. What does this Creative Commons license mean to me? It gives me the more than wiggle room that fair use would otherwise give. Okay, the definition of the term quote, share, unquote, in the Creative Commons terms do not expressly include reviews. Or does it? It's more of a psychological effect for me than a legal one. But surely, this definition covers parodies, cosplay, fan art, and memes, right? Let me read the definition of quote, share, unquote. Quote, share means to provide material to the public by any means or process that requires permission under the licensed rights, such as reproduction, public display, public performance, distribution, dissemination, communication, or importation, and to make material available to the public, including in ways that members of the public may access the material from at a place and at a time individually chosen by them. End quote. The licensed rights are what compose copyright. I explain further in a future video. If that video is live now, a link should appear above my head. Part 6. Way Forward. I hope this video convinces the Japanese government to adopt fair use in its copyright law. I also hope this video shares awareness on the importance of fair use. Lastly, I hope this video teaches and warns reviewers and fans regarding what they can do and cannot do regarding anime and other media, shows, music, and even video games made in Japan. I don't know how long it takes, but let's imagine that fair use eventually becomes part of Japanese law. Is it enough?